What happens when law, business, and life collide? Each week on Lead Counsel, your host Tom Tona will take a deep dive into topics related to the law, the business of law, and life. There will be insightful discussions with industry insiders, experts, and thought leaders making significant contributions and meaningful differences in their fields of expertise. Tom is the founder and managing attorney at TonaLaw. He has been a practicing attorney since 1994 and the leader of TonaLaw since it opened in 2001. The goal of this podcast is to provide you with free information on law and the business of law, and to give you actionable tools related to each of these areas. Now, here's Tom.
Hey, welcome back to the Lead Counsel Podcast. Your host, Tom Tona. Before we jump into today's topic, I just want to take a minute to thank the sponsors of the podcast. This episode is sponsored by TonaLaw. They're not just another law firm. They're defining what it means to fight for their clients. We get a lot of attorney referrals from across the country. We pay fee participation in all jurisdictions where it's permitted. We focus on integrity, innovation, and relentless advocacy. TonaLaw is proving that the business of law can scale without losing its heart. If you want to see how a modern firm is built for impact and happy client referrals, check out TonaLaw.com. Mention again the Lead Counsel Podcast, and I'm happy to get on the phone with you. This episode is also brought to you by Meet Gabby, the voice AI built for law firms. Gabby answers your phones 24/7, qualifies leads, and books consultations so you never miss another client. Imagine cutting intake time in half or giving every caller a 5-star experience. That's the power of Meet Gabby. Learn more at meetgabby.com. Mention the Lead Counsel Podcast. You can also hit me up, and I'm glad to make an introduction to the owner. This is the final installment of the Succession Planning Experts Roundtable with Ed Alexander, John Hawkins, and Daniel Feiman. Welcome, gentlemen.
Thanks, Tom.
All right. I appreciate everybody hanging in there. So we're going to just do Q&A town hall style. First up, Ryan McKean. I'm part of Ryan's Best Era Slack channel. Ryan sent me in 3 questions. I'll hammer them out one by one, let you guys answer them. We answered this one, I think, but he has the best timing for succession planning. Is it a year, 2 years, 5 years before the exit? Before the exit. So if I want to exit at 65, what's the ideal time to start the process?
3 to 5 years before you want to exit.
3 to 5 years is ideal.
Well, no, ideal is now, right?
Okay.
Good point.
Right. But no later than 3 to 5 years to give it a proper window of not just the planning, but the execution.
Right.
Yes.
It's the execution that always takes longer than the planning.
Okay. And, John, you brought up an excellent point. Not every firm is run the same way. What I like is that we all, and I include Dan in this, are part of these groups where we know the entrepreneurial law firms like Atticus, GLM, How to Manage. Dan is part of a bunch of groups out in California for succession planning and all of those different things. So you probably can shorten that time frame a lot if you already have it set up to run like a business with a management team and a leadership team, that type of stuff. So, all right, Ryan's next question was, and I think you answered this, where do buyers obtain capital assuming that they don't sit on a pile of capital? SBA under 5 million, traditional over?
SBA is the best source for under 5 million because you can basically put 10% cash in. It is also, though, most expensive because you pay a guarantee fee and some pretty high closing costs, and your interest rate is higher than market.
So let me ask a question when you get a chance. On the SBA, I'm not super familiar with that, Ed. So my understanding is it used to be you had to buy 100% of the business, but maybe they fairly recently updated the rules where you can do a partial buy.
No. So what you do is if you're going to do an internal and you do a multi-step internal, so you bring somebody on at a smaller percentage, the target there is to get them to 10%, and the owner finances that themselves, right? And so it's really that initial transaction. And then when the owner leaves, dies, disability, whatever, then that becomes a partner buyout loan. And that is the balance of the business at that point.
So the way you structure it is important on the SBA.
100%. And that's why we usually do the 10% as the initial tranche for them to buy in, because once they get to that actual ownership of that 10%, which takes a little while, 5 years, plus or minus, then what happens is they're able to go out and finance the balance. So the owner essentially free and clear at that point.
Okay. And quick question on the SBA. Has it changed? I know back in the day, and I'm going back 25 years, you had to sign over collateral and it was personal collateral. Like you had to sign over collateral on every piece of real estate you owned. So has the SBA changed the way that looks for these types of transactions?
So I'm not the SBA lender expert, so I'll tell you that. But it's my understanding that if there is collateral available, they take the collateral. So typically that's a home, and it depends on what your mortgage is, what your net equity is in the home, all of those things. Right. So there's that. They were going to take a first on all of the assets in the law firm, and then they have
obviously,
personal guarantee too.
Yeah.
So another question. Let's say somebody like Tom is out there and they want to go gobble up 2, 3, 4. Is there a limit on how many SBA loans he can line up to buy those? Does he have to do one?
It's just a $5 million limit, okay. But ultimately that would be a little bit of an expense because, each time you're doing it. So I would strategize to what's the best way to actually make that happen.
Let me ask you a question. Go down this rabbit hole really quick. First of all, I'm never giving mortgages on real estate. So if I was going to do SBA, that's kind of a non-starter for me. But can you structure a law firm finance deal where a lawyer just has some wealthy friends that can put together some money at advantageous terms? Can you structure that where a lawyer is able to do private finance arrangements with money guys or money gals? You know what I mean?
Absolutely. As long as it doesn't look like equity. So no profit sharing, right? But if it's a true loan, no problem whatsoever.
No profit sharing, you said.
Right. Because you can't share fees with non-lawyers.
Gotcha. Okay.
And for you, Tom, you wouldn't have to go with SBA because you'd be likely able to go out and get a loan with what you have now.
Right.
Yeah.
Right. And Dan comes from the finance world, so he can get that's what we're working on, is making sure that my numbers all look like they're supposed to look for traditional finance, right? Dan was in the banking space for a very long time. So that was a method to my madness in bringing Dan into this mix. And then the last question Ryan had was, how do firms transition organizationally? Equity switches power dynamics. What are some things that work and some that don't?
Well, from an equity power perspective, what I've done is we've set up voting and non-voting equity, which you can have in it. Most firms are S corps, right? So the pass-through entities, and they have limitations on the different types of stock that you can have. So you can't change the economics, but you can change the voting. And so you can have the founder, like Tom, would retain most or all of the voting shares and then bring people in at non-voting until such time as, maybe 5 years, 7 years, 10 years, whatever the window is. So that's ways I've structured it in the past.
Yeah, it's effectively an earn-in. You're giving people, this goes back to the whole concept of succession and leadership development, you're giving people an opportunity to earn in, so to buy up to whatever their role is.
Okay.
And I would just add that, lots of variations on this, but similar to both of these, it's, you can have the seller retain sort of control up to a certain point, and at which, once you get past that, then they hand it over. And that way you're sort of protecting both.
All right. Okay. So this question comes from Charlie Mann. Charlie's a friend. He's a business coach for lawyers, and he sees these questions a lot. So one, do you need to, or should you make equity available to a key player who might take over the firm? Right? Like he's making it sound like a golden handcuff situation where you got somebody who's really good on the production side. Is that something that you should do or need to do so that key player is vested? And I'll give you an example. I have an accountant friend he said the way they did it with me was brilliant. They gave me 2%. And I had to buy in the rest, but they gifted me 2% when I was a young, hungry attorney. I was a partner, named partner. He got 2%. He had to buy in the rest, right? So I think that's what Charlie is asking.
I would always caution against just giving it. I would really have a conversation with that person to ask them, what does partnership mean to you, right? And see what they really want so that you can tailor your solution to them. But if you do it, better have a really good shareholders agreement or partnership agreement so that you can buy it back cheaply if they leave. You've got mechanisms in there. So that's
Oh, because you're basically married. So if all of a sudden there's a fallout, you want to have those things kind of auto execute is what I'm thinking, right?
Really good on-ramps and off-ramps, to use Jonathan's language. I love that language.
Yeah, which is what John just did. I think before we turned on the mic, I've got this other venture I'm working on, and I got this paperwork in, and I was a little overwhelmed. I got to send out paperwork to 5 different people. And he goes, well, yeah, that's part of the process, man. You need all these, and it's got all these auto executing on ramps and off ramps. So I really liked what he did. I don't like to read paperwork. So I spent most of my morning wrestling with the paperwork he sent over. And again, I really appreciate that approach, because that's why I look at this stuff, because I don't have the ability to see what that could be down the road, right? All of a sudden, it seems like a good idea, and you want to make sure you have those safeguards in place for both sides, really, right? The last thing somebody wants to do is be married for 2%, and all of a sudden, it's not the scenario they want either, right? So.
Yeah, I've seen scenarios where it's a 50-50 partner and they bring on an associate 2%. Well, if the 50-50 partners start fighting, now they're 49-49. Now the associate controls the firm. All they have to do is decide which side they want to be on.
Oh, man, that's a horror story.
To this point, the vast majority of people, since Tom used the term, this was like getting married. When we get married, nobody wants to talk about a prenup. But what percentage of marriages end in divorce?
Right.
There is just a lesson in maybe we should have a prenup. Maybe since I'm drawing it as my firm, I'm going to have it kind of advantage me until I'm ready to walk away. That should be non-negotiable.
Right. And, to that point, too, and John, I know you do a lot of litigation in your practice. There is no fight nastier than 2 lawyers breaking up, other than maybe if, you got a disgruntled spouse you might have been unfaithful to, right? So, I mean, John, I know you've seen horror stories in the litigation realm because of this, right? So, yeah, I think that proper on-ramps and off-ramps, and to Dan's point, there's no better time when I'm the owner of the firm to have it drawn up the way I want it drawn up. Right? I'm the one who put in the millions and millions of dollars in blood, sweat, and tears into the practice. I should have the contracts drawn up in a way that just protects me, right? And going into it with the best intentions, but protections, right? So that makes a lot of sense.
And write it out, but sign it. Make sure you sign it.
Right. Well, listen, that's the good thing about getting bills from you guys is you're going to make sure it gets signed. You're going to make sure that everybody understands the ramifications and it's all spelled out. So that to me is important. Charlie had another question, which was, how does your family get paid out? And I'm assuming that's in the context of somebody passes away or something like that. But you guys have already answered that. It seems like there are layers of insurance you can deploy, that seems to be the primary protection on top of personal life insurance, right? So if I have personal life insurance right now for my family, then if I end up with a succession plan with Dan, where all of a sudden I am going to bring on an internal successor or even external, there's got to be some layer of life insurance that allows them to buy my family out immediately, take over the files, and run with the practice, right?
But there are circumstances where one or more of the partners are uninsurable. And so in that case, there's got to be a financing mechanism built into the partnership agreement.
Okay. If they're uninsurable.
Well, sometimes I structure, like particularly with plaintiff law firms, sometimes you got a portfolio of cases, but sometimes you got some big potential, very, very big cases. And so life insurance may not be enough to really compensate for that. So it may be a combination of, we'll give you some life insurance payout, but also you get a piece of any of these cases that are there in the portfolio as of the date of death, for example.
And you can do that in a way that passes muster because it's not considered fee sharing?
Yeah, it's a buyout. It's the price. It's just paid out over time.
Gotcha.
Again, I'm not giving legal advice on this, but from my perspective on, the portfolio that exists on the date of death is what you're using to value. If you're signing up cases into the future, those new cases that come in, I think that would be fee sharing. So you couldn't do that. And I've had people try to do that, but in my opinion, I don't think you can.
Right. Okay.
There's a comment in the rule that specifically points exactly what Jonathan just set out, right? That you can pay the spouse or family of a deceased lawyer.
Right. Okay. You can.
You can.
Yeah. Okay.
And we focus most of our conversation when it comes to insurance on life insurance, which everybody's going to die. The reality is your 30s, 40s, and 50s, you are more likely to be disabled than to die.
We forgot about disability insurance.
Insurance is huge, and it's probably the most common that is completely ignored.
It's also problematic because by the time you think you need it, it's too late. So like I'm 57, I can't get an owner-occupied policy that makes sense. I cannot. I've gotten quotes on it. It's so crazy expensive unless I was to do a group plan, I was told, for my office, right? Go ahead, John, expand on what the workaround is.
I'm not an insurance expert, but I do think the bigger you grow, you have more options on pretty robust group policies that when you spread it out are a little more affordable and maybe less onerous in terms of, the application process.
So again, if you're in your 30s and 40s listening to this, the time to get a disability policy is right now when you're healthy, before you become 57 and God forbid your doctor puts something on your medical records and all of a sudden they triple the price or the 10 times the price on you. So, but again, the workaround for people that might have waited too long is a group plan for your business that you fall under without worrying about having to qualify, is my understanding. Like you just get a group plan, everybody, there's certain amounts of insurance, but I don't know how high they go with that coverage either. And then Charlie had one more question, which is, okay, you start out with let's say it's an internal successor. Day one, here's the plan. Here's how we valued it. We both agree. Then do you do repeated annual valuations to then see what the equity buy-in is worth the following years? How have you structured that?
I've seen it done both ways, where you just come up with a valuation on the front end, even if you're going to do buy-ins over time. And then I've seen other situations where they're like, no, we think the firm's going to keep growing. So if you do your first buy-in now, we're going to use a valuation. And if you do another one in 5 or however many years, we're going to do another one. Okay. So I've seen it both ways. I don't know. What have you seen, Daniel and Ed?
Well, I've seen the periodic valuation, whether it's every year or every few years, particularly on the periodic buy-ins, because just to your point, Jonathan, if I'm going to have my first buy-in today and then again in 4 years and then a third piece in 8 years, the firm, hopefully for everyone, has grown, but my buy-in needs to be proportional to the valuation of the firm at that time. So Usually you sync those two, the buy-in to the valuation, those.
And so you're applying the same formula with updated metrics, basically.
Tom, I want to just stop that. Nobody said anything about a formula because your firm can change, right? And so the valuation, if you set a formula, you may be missing the valuation. So just be careful about that, right? And then the second piece of it, I think, which is really important, is that from an IRS perspective, if you're transferring something of value to an employee at less than fair market value, the IRS considers that disguised compensation. And so that could have negative tax ramifications for both the firm and the employee. So you got to be very careful there. There are some safe harbor rules, but you got to be careful.
Quick break to thank Meet Gabby, the voice AI that answers your phone, screen leads, and books consults 24/7. They'll even send out retainers if the person on the other end of the phone asks for a retainer. If intake is slowing you down, check out meetgabby.com. This episode is supported by TonaLaw, a modern law firm built on integrity and innovation. Learn how they're changing the game at TonaLaw.com. Attorney referrals accepted from across the country. You'll see what it's like when you send us a case. You'll have some happy clients. So when we asked the question in one of the previous episodes about who to have at the table, you definitely need a tax planning expert / lawyer / accountant type that can give you all of the 360 on that, I'm assuming, yes?
Yes.
Absolutely.
Right? Okay. Because there are ways to structure it to minimize the tax bite, but you don't want to run afoul of that compensation rule you talk about, disguised comp. So, okay. This one came from Ryan Fenton. When law firms are preparing for succession or sale, especially in fields like family law where relationships drive so much of the business, how do you make sure that the client acquisition systems are transferable so that the firm is retaining their value? And I did have a similar question, so I'll phrase it to you this way. What have you seen the impact to be on clients of law firms that do these transactions? Like, is there an attrition rate? What's the best way to do it messaging wise with clients, that type of stuff? You're smiling, Dan, so you get the first answer.
It's like any other acquisition of A is buying B. You've got a marketing message you've got to get out there to the client base and the prospective client base. There is no reduction in service. You're still our most important element. You don't want to say commodity.
Right.
You've got to communicate to the marketplace that nobody's going to drop the ball. You'll get the same or better service now because we have more capabilities. I've seen this in law firms. I've seen this recently a lot in accounting firms, in veterinary practices. Our vet got gobbled up by a big national entity, and the first thing they did is sent out a soothing letter. As much as we cared about your dog before, fill in dog's name, we will care more moving forward. So a law firm has the exact same situation where we need to communicate to the marketplace things are going to be as good, if not better. We're going to hold your hand. We're going to get you the result, etc.
So it's almost like you have to have a PR component to this type of transaction to make sure to keep the adverse impact with clients minimal. Whether it's even bringing on somebody internally to handle that communications, working the telephones on a smaller transaction. But from a messaging standpoint, it sounds like it's all about the messaging.
Depending on how you structure the sale and how it all goes down, there may be an ethical requirement that you notify the clients and give them a choice of whether they stay or go. Again,
You're laughing because you know I'm cursing, Ed, man. I can't stand all these rules, man.
I think it was 1.17 or whatever. It depends on the state. 1.17, 1.1, 1.18. But it allows a sale. Now, I'll tell you, functionally, that rule makes it really hard to do a sale under that sort of structure.
Right.
There are other ways to get at it but potentially you have to disclose in certain circumstances.
Certain jurisdictions, right?
And again, the way you structure it. And not only disclose, but they have to sign on to the new place.
Okay. So like a new retainer.
Well, some states require the approval. Other states, if they don't respond, but you can prove you provided the notice, right? But, you use the notice the way Daniel said. I mean, that's what I always counsel.
Right.
This is a marketing document. You have to include 3 things. Include those 3 things, but make the rest a marketing document, right?
Right. Here's why you want to stay with us. You'll be so happy type of thing. I like it. And look, again, I think that goes for every area of practice. I think that people that are paying attention to the client impact are going to be winning the game when everybody else is looking at how do I get robots to replace people. I'm doing both. Like I want robots, not necessarily to replace people, but improve efficiencies. But I still need that personal touch with the clients. Like I'm not going to lose that because that to me is at the heart of everything.
Tom, I just want to point out one thing is I've done these deals. I've never seen all the clients leave. Never. And,
okay.
And so ultimately, right, it's all about you choosing the right buyer, right? And the buyer being capable of going out there and creating relationship.
Right. And messaging. And also, I'm assuming you want to keep some kind of skin in the game to the seller who has an incentive to make sure those clients stay. So, Dan, you're smirking again. So go ahead, take it.
Where you can hold their feet to the fire for the transition period, absolutely. But Ed said earlier, the seller's not going to be there for more than a year. So you've got to have a handoff plan and try to predetermine what's your attrition rate likely to be. And the more acquisitions you go through, the more people you talk to, like Ed and Jonathan, about the attrition rate of this type of firm or in this geography, the more you can get your arms around, okay, here's the book of business. This is how much we might be able to realize out of it from a client retention standpoint. And then what's our success rate with the rest? That gets down to the cash flow number that Ed's going to use to value it. And we're going to say, yes, this firm is worth X and they want 3X. That's when you say, nice knowing you, next.
Right. Do you guys have some kind of fallback statistics on types of firms and jurisdictions and what the attrition rates to be? 10%, 20% attrition rates? Do you guys have any of that stuff? One of the things that would be interesting KPIs to ask for is, tell me your average non-recoverable, in a PI setting, non-monetary recoverable attrition? How many clients have left your practice over the last 2-3 years on average with no recovery, meaning they fired you or you fired them? And whether or not they're going to be honest about it, that's the other thing, because it's the honor system. And so, I don't know if that's a realistic kind of KPI to go by.
You would think you'd get that information from their practice management system when you do due
You
diligence.
could, yeah, you could look at, like in New York, OCA closing statements or whatever. But again, it's all subject to, are they playing by the same, rules?
One of the piece of that question, I think, was, and Ed calls these brain surgery firms and something else firms. But, part of it is, it's one thing about the client, the portfolio of clients there, but also sort of the client acquisition system. And so this is a valuation, big piece on the valuation. If it is a heavy referral based, referral to the attorney based kind of practice, it's going to be on the lower end on evaluation, where if you have systems of digital, working your list, whatever it is, ways to bring those clients, continuing to bring in new clients.
Right.
You want, as a law firm owner, you want to move as much as you can to making those systems as robust as possible. So it's not just referral to Tom Tona, to Tom Tona.
And I'm seeing more of that right now on those transactional potential acquisitions. Again, digital changed a lot in December. So a lot of firms are trying to figure that piece out right now, right? Because Google just decimated personal injury firms in general. So yeah, that's good advice. How many people have systems versus the other thing? That's going to be a whole nother, this topic for another day. Two good friends that you guys will recognize, you may know the names. Michelle Fuller, she asked the question, how do you determine if a firm is worth acquiring? Two colleagues approached me to do this who are in their 70s. Great lawyers, great firms, don't know. So I would probably say you got to get in touch with a Daniel, right? Like you got to be able to plug in or Ed, right? Either of you guys that can say, hey, but again, Michelle will be the potential buyer, right? So Ed, it sounds like you're more working with sellers that would pay for a BPO, right? A broker price opinion. But I don't know, like, what's the advice for somebody like Michelle? She's asking kind of the same questions I am, where I don't know if they're great practices. Dan's got a matrix for me to start plugging stuff into. But Ed, is there would she be working with you? Could she work with you?
Yeah, we represent buyers. At the end of the day, it's that preliminary analysis. And then is it worth moving forward? We take the next step. Is it worth moving forward? We take the next step, right? It's testing all along the way. In the brokerage, one of the agents that we have there, he always has ABTB, always be testing buyers, always be testing buyers. And it's the same exact thing. Always be testing sellers, always be testing. So one test after another.
Dan, I can't wait to take your spreadsheet, plug it into ChatGPT and work some magic that I don't even have to do anything other than run the financials through it and just see from there. Now you got me thinking.
Automate everything, Tom. We don't need any human input.
Well, but again, you're going to show me how to do it so I can train the bot. But it'd be really interesting to see how fast I can get this analysis down, plugging stuff in. Because again, like Michelle.
It's a template, Tom. It's a starting point. It's not an ending.
Right.
I can't remember if Jonathan or Ed earlier said something about, okay, we're going to start with a number and then we're going to add and subtract from there.
Correct.
You can use this template when someone says my firm is worth $5 million and your template says it's worth $750,000. Okay, that's an automatic no. But aside from that, if you're within some reasonable range between what your model says it might be worth and what they're asking, then you have further conversations.
I wish it was only a $250,000 differential right now. Like, I'm going to be excited to actually test your models out with real data and see how that shakes out.
I would say, to answer Michelle's question, piggyback on what these guys have just said.
Yeah.
Should you buy a firm or not? Run it through your spreadsheet. And if it says it's worth $1 million and they say they'll take 10,000, do the deal, right?
Right.
It all depends on the price.
Normally it's the converse. They want $4 million for a firm that I've got to now spend $500,000 on each pod, and I need 2 of those pods, so it's lowering the net by $1 million. And I go, I mean, look, I didn't pencil anything out further, but it sounds like we might have a discrepancy here. So,
well, Tom, the other thing to remember in that is that the terms are as important as the price, right? So if I want $10 million, but I only have to pay you 20% of cases that come for the next 20 years,
right.
All right, well, if we define where those cases come and they come from your marketing machine, okay, I'll pay it that way. Why not, right?
Right. So, Luke, that's the last question that I had. I don't know if you guys saw anything else that I missed, but I really want to thank you guys for doing this. I think that there was a bunch of reasons why I wanted to do this, right? Selfishly, I love learning about this because some of the people's names I brought up, they were all negative. Nobody acquires firm. Nobody sells their firm. You basically just doomed to die at your desk. I think you've dispelled that myth. There are successful transactions going on. A lot of it has to do with planning and intentionality, right? And I would encourage anybody that's listening to this, Eddie, you confined to just Florida on the transactional side right now?
We do transactions in multiple states. So we'll do them, you mentioned it before, we'll do it in New York, right?
Okay.
There are certain states we would need to be licensed, and we have relationships with other brokers in those states, but the states we're licensed in is Florida, and then obviously other states we don't have to be licensed in.
So, but that's the brokerage side you're talking about.
Right. And on the law firm side, we'll do work in other states. We'll work with local counsel.
Okay. And I know, John, you've got somebody from New York, and you've got similar model where you've got people kind of in branches all over. And then Dan, you're working with people across the country. I know, because I've been referring you people all over the place when they're actually at the point where they are serious about, succession planning. I don't want to waste anybody's time. Thank you guys for doing this. I took a lot out of it, and a lot of it, after I stopped the recording, just resonated with me, like what I need to focus on. The missing middle that you talked about, Ed, or the different financing options that we're talking about, and that type of stuff. So it really does resonate, and hopefully it resonated with people because there's too much noise out there. What I do like the idea of is that this is doable, right? Too many people are like dismissing it, and it's doable, but I think you got to start early in the game, right? And I'm very serious about it. Like Dan and I have been dancing around for a while. Like I'm serious about it, but I'm assuming you guys have both done this, right? Ed and John?
What do you mean?
What?
Have you done your own succession planning for your firms?
I know what my succession plan is, if that's what you're asking.
Right. Okay. Yeah. I'm just saying, like, you have a succession plan, right?
Yes.
You guys definitively have to be those guys, right? And John, I know you're scaling right now, but you have some kind of.
Well, I have my hit by the bus plan in place for sure.
So I want to wrap it with this story. If anybody's listening to this, I was flying to Paris. I think I told Dan this story. And all of a sudden, we're about 45 minutes into the flight, and we took a night flight knowing we were going to arrive in Paris for the morning. And there's a loud crash. Big blazing red thing right outside my window. I'm sitting by the wing. I'm in first class. My wife and daughter are in the middle row, and I see fire. And I said, holy shit, like, this is how it ends. It's over. Now it's 10:30 at night. I'm dead serious. This happened. And everybody in the plane, I'm looking around, everybody's about to panic, right? It was my wife and daughter are crying, and first class, people are scared. And I'm looking, and all I see is the orange glow of fire. So I'm thinking in my head, I go, either we got hit by a missile or the engine blew out. This is how I died. That's what's going through my head. And the first thing I'm doing is texting Janira. Listen, I don't know what just happened to my plane, but you know what to do if I don't make it out of this. This is my flight. This is the number of the flight. Turned out the plane, they come on like 10 minutes later. We heard that. We're investigating it. Not making anybody feel bad. Turned out it was hit by lightning. The wing right outside my window. And I'm telling you guys, I didn't sleep the entire flight to Paris. I was like, I'm thinking this plane is going down. And it was scary. And, and I remember relaying that story to Dan saying, oh my God, like, you never know. Like, you gotta do the planning on this stuff. Because what would happen if it was me, my wife, and my daughter? God forbid, what happens then? What happens to all of the finances and everything within the firm? And luckily, I had a short list of this is who you call that will easily pay full value, or my next of kin will get a check. Maybe it won't be full value, maybe 50 cents on the dollar, but somebody will get a check somewhere. But get these people in play, right? Because they want the practice. They'll handle it. They can just absorb it in the blink of an eye and monetize it. But I will leave it with that story. it can happen at any point to anybody. So like wake up, do the work, and call the people on this podcast because they know their stuff. So guys, I appreciate you coming on. Any final thoughts on anything?
Thank you, Jonathan.
Yeah.
Thank you, Daniel. Thank you, Tom.
Thanks for having us.
Thank you.
Thank you for listening to this episode of Lead Counsel Podcast. Your host, Tom Tona. Go anywhere podcasts are distributed. Follow us. Leave us a 10-star review. Share some episodes with your friends. And thanks for listening. I appreciate it. Thank you. This episode is sponsored by TonaLaw. They're not just another law firm. They're defining what it means to fight for their clients. We get a lot of attorney referrals from across the country. We pay fee participation in all jurisdictions where it's permitted. We focus on integrity, innovation, and relentless advocacy. TonaLaw is proving that the business of law can scale without losing its heart. If you want to see how a modern firm is built for impact and happy client referrals, check out TonaLaw.com. Mention again the Lead Counsel Podcast, and I'm happy to get on the phone with you. This episode is also brought to you by Meet Gabby, the voice AI built for law firms. Gabby answers your phones 24/7, qualifies leads, and books consultations so you never miss another client. Imagine cutting intake time in half while giving every caller a 5-star experience. That's the power of Meet Gabby. Learn more at meetgabby.com. Mention the Lead Counsel Podcast. You can also hit me up, and I'm glad to make an introduction to the owner.